Thank you, Senator. With respect to the impact of the unfilled vacancies, first, we are so grateful. As a sitting trial judge on the D.C. Superior Court, I am especially grateful. I know Chief Judge Lee is as well for you considering the nominees here today for both the Court of Appeals and the trial court. With the lack of judges, it decreases, as Senator Hawley observed, the number of cases we can hear. The average judicial officer in my civil division that I'm currently in, I spent the 4 years in the criminal division, I spent 3 years in our family court division, and the numbers are skyrocketing. They are quite high. And I work as absolutely hard as I can, but there are only so many hours in the day, and we can't get to all the cases, and it does create that backlog. And those numbers are real, those cases are real, the litigants are real, and those delays are felt by those who are not able to get justice.
Mr. Nash?
Well, thank you, Senator. On the one hand, I feel a little bit odd talking about the difficulty in moving nominations through the process because Judge Kroll and I were nominated just this month, and so this committee has moved with great alacrity to put us on this panel and to do this hearing, and certainly everyone sitting on the dais this morning and the staff behind has nothing to do with the delay in the filling Court of Appeal slots, because you all have been nothing but gracious in moving our nominations along at quite a great clip. But Senator Hawley, I think, in his opening remarks, really put the statistics to this problem. One of the seats that I guess the seat that technically that Judge Kroll was nominated to has been open now for 13 years. So it's been at least 13 years since the Court of Appeals has had its full slate of judges. And so, you know, I know Judge Kroll by reputation. Myself, I know both of us are really looking forward to rolling up our sleeves, getting to work. Given our experience in the Superior Court, I think we're in a position to hit the ground running when we hit the Court of Appeals, and if we're fortunate enough to be confirmed, and forward to doing our share to try to drive those numbers down and get the point. I mean, right now I'm a consumer of justice in the District of Columbia. I'm a practicing lawyer, and it takes a long time to get a decision, both in the Superior Court and the Court of Appeals, and we're committed to do what we can to make
that challenge, it's something that makes everything not just slower, but more expensive and just more difficult to be able to navigate for everybody. Is that right?
There gets to be a point, honestly, on the civil side where litigants will decide that they're just going to settle their matter rather than wait interminably for a trial or Court of Appeals. And it wasn't that way when I was serving on the Superior Court 10 years ago. This is a problem that has, for whatever reason, become more of a problem in recent years. Yeah. And
it has that impact. I mean, it makes, as you said, people start to not believe in the system in terms of its ability to function. And, you know, this is by virtue of the values that our country has in terms of giving people their day in court and being able to do that in a timely manner. And I just think at a time when there's such distrust in government, we need to show that we're doing the nuts and bolts and being able to deliver in that type of way. So again, you know, I'm very grateful to Chairman Hawley as well as Chairman Paul of the full committee for moving this forward, for recognizing that this is an important function of this committee and necessary for our capital. With that, I'll turn it over.
Very good. Mr. Nash, if I could just start with you. You wrote an opinion piece in the Washington Post in which you state, and I'm going to quote now, the D.C. Court of Appeals has become a substantial and underappreciated obstacle to reducing the city's high rate of violent crime, regardless of who has control of the police. Could you just elaborate on what you meant by that and what perspective you might bring to this position in light of your views here?
Thank you, Senator. My opinion piece related to a specific case that came to my attention because, as you know, the Court of Appeals sits in 3-judge panels, and the Court of Appeals rendered a decision in a criminal case where 2 of the 3 judges who were on the panel, a unanimous decision overturning a gun conviction, 2 or 3 of the judges on the panel said in writing in their opinions that they were uncomfortable with the way that they were coming out. They believed that their decision was inconsistent with Supreme Court precedent, and yet they felt compelled by the precedents of the D.C. Court of Appeals to come out the way they did. I practiced law for a long time. I had never seen a decision come out unanimously with 2 of the 3 judges saying they didn't agree with their own decision. And I thought that that was an interesting enough phenomenon that it was worth writing about. I looked at the case. I came to the conclusion that in my piece, I came to the conclusion that the judges who had expressed reservations about the opinion were right. That's what I wrote in the opinion piece. And it turns out that I wrote that last August, this winter, the U.S. Supreme Court weighed in on the decision and reversed the D.C. Court of Appeals, not in the specific case that I wrote about, but in another case on that same issue, saying that the issue that I wrote about, the D.C. Court of Appeals, should be reversed.
This was DW versus the United States, I think was the case. Is that correct?
That's the one I wrote about. The one that the Supreme Court later wrote is confusingly enough called United States versus RW, but same issue, different case.
Well, sticking with the DW case, this is the Court of Appeals panel, as you said, threw out a defendant's gun crime conviction, even though, if I remember correctly, you correct me if I'm wrong, the defendant's lawyers admitted at trial that the defendant illegally possessed a firearm.
That's true. That's not an unusual circumstance. The defense was that the police had acted inconsistently with the Fourth Amendment, and so it's not uncommon for lawyers to challenge the Fourth Amendment issue if they lose on the Fourth Amendment issue.
This is because not to interrupt you, but just to mindful of the time here, this is because the D.C. Court of Appeals had previously held that running away from officers unprovoked, this is a quote from the controlling precedent, does not provide a reasonable basis for suspecting that individual being involved in criminal activity. You said in the op-ed, most non-lawyers would, I think, concede that unprovoked flight provides an officer with sufficient reason to establish whether the fleeing individual might be involved in criminal activity. That seems very commonsensical to me. Here's my question. Here's really what I'm driving at. What does this mean for your approach to the role? If you're confirmed to this court that you've written about, does that mean that in cases, let's abstract from this particular precedent, in cases where you think that the court's precedent or previous cases is wrong, will you push to have those reviewed